Hello, and welcome to another edition of Court Rise with me, Martin Kpebu. Today's episode promises to be quite another interesting one at that. We are all aware that properties, and especially in the context of marriage, is usually a matter that evokes a lot of arguments, and then also when there's divorce, it brings a lot of acrimony. That is to say, when it comes to the distribution of properties acquired during marriage. Yes. So today, we are going to deal with the matter of the distribution of marital properties. Yes. When a divorce arises. So the context is distribution of properties acquired during marriage, not any other distribution of property. So if you have a contract between yourself and another person and it says properties be distributed in a certain ratio, etc., that is not our subject. Today, we are limiting ourselves to the distribution of the properties in the context of a dissolution of marriage. That's when the case goes to court, or in certain instances, if the parties want to dissolve the marriage at home. That is when it's customary marriage, So, but let's put this caveat even before we continue. When it is customary marriage, yes, the law allows the parties to dissolve the marriage at home. They can also distribute their properties. However, if that distribution doesn't go well for one of the parties, or put in another way, if one of the parties is not happy with the way the properties have been distributed, the law allows that party to take that matter to court. Yes. So usually, the customary marriage, when it's dissolved, it's elders who sit. The elders may not be tutored in law. So sometimes they also have their own rules for dissolving the marriage and distributing. Sometimes you find them trying to punish an adulterous woman because she's been adulterous, then it's like she'll get nothing, etc. No. The law doesn't work that way. If an adulterous woman contributes substantially to the acquisition of the properties, you can't say that because of adultery, she will go out of the marriage empty-handed. There's no such law. That's just one example. There are other ones. But today we are not talking about the rules that our elders use in dissolving marriages. We can look at that another day. Today we want to look at how the courts go about that. So the seminal case we will use for today's discussion is the case of Gilbert Anyete versus Susan Anyete, husband and wife. Yes, this is a decision of the Supreme Court that was given in March 2023. So when we say Supreme Court, then I'm sure from our previous episodes, you know that it means that most likely this is a case that has traveled from the High Court to the Court of Appeal and then finally to the Supreme Court. Yes, that is the case in this particular case. So I'll give brief facts of the case, and then we would go into how the court dealt with the distribution. So the brief facts of the case are that Dr. Gilbert Anyete got married to Susanna Anyete, and shortly after the marriage, he left for South Africa. And then soon, Susanna had to join him. Fast forward, when Susanna went there, she worked as a biochemist in a brewery. Then shortly for about 2 years, and then after, she decided to set up her own hairdressing salon. Okay, and then the doctor worked as a doctor for the government of South Africa. Then later, he also set up a private practice with another Ghanaian doctor. So in all, the marriage lasted about 20 years. By the time they were done, they had about 15 properties in South Africa, 15 landed properties in South Africa. So at least by some standards, that must have been a very successful marriage and a successful business, right? On both sides, the doctor's practice and then Susanna's hairdressing business. And then also there were 2 properties in Ghana. So when it came to the distribution of the properties, as I said, because our focus is on the distribution, we are not able to talk about the marriage itself, etc. No. So it turns out that when Susanna went to South Africa, the salary she earned from her work, she gave to Dr. Anyete. And then also, when she stopped working, that's when I say stop working, that's when she stopped working in the brewery. The pension she got, she handed over to the husband, Dr. Anyete. Then she set up the salon. Now, for the salon, it's also part of her case that she would give money from the salon to her husband. And also that there was an agreement that she should use the rest of the money she got from the salon to take care of the domestic expenses, whilst the husband invested in landed properties for both parties. So that is her case. Now, in the High Court, the court decided that yes, based upon these facts that I've read, or these facts that I've stated above, she was entitled to 50% of all the properties that were acquired. So the husband, that's Dr. Anyete Gilbert, wasn't happy about it, so he appealed to the Court of Appeal. The appeal was successful. The Court of Appeal, in brief, that's a summary, held that no, they don't agree that Susanna had contributed sufficiently to get 50%. So we soon come to the rules, but briefly, the law doesn't always require 50%. It depends. The judges will weigh the contribution, so it can be 30-70, 60-40, 80-20, etc. Right? It all depends on the facts, what happened in each particular case. That is where the emphasis is. So the Court of Appeal looked at it and thought that no, she didn't merit 50%. So they sought to cut back. So because Susanna wasn't happy, she also appealed to the Supreme Court. So we would now take a bit of time and look at what the Supreme Court laid out as the rules for distribution. Those are the same rules that the Court of Appeal also used, but we have different ways of interpreting rules. Yes, it depends on the philosophy of the person interpreting. So sometimes the same rule, two different sets of lawyers will come to different conclusions. So this is what happened in this case. So as we are going into the rules, let's remind ourselves, or let's state firstly, that the Supreme Court wishes to inform the general public that they have never stated anywhere that on the dissolution of a marriage, every property that is acquired during the marriage must be shared 50-50 between the parties. Yes, the court says they've never said so, and that anybody who comes on air to tell you that in Ghana on dissolution of a marriage, the properties are shared 50-50, it's misleading you, and we'll soon go into those statements. Yes, indeed, I can identify and understand what the Supreme Court is saying, because some lawyers had been misreading and misinterpreting the previous decision of the Supreme Court. That was way back in 2012. It's called Mensa and Mensa. So we'll read the portions of Mensa and Mensa that lay down the rule, and yet which were being misinterpreted by some lawyers and also some non-lawyers. So rule number 1 for today, the Supreme Court has cleared the air that don't misquote them, don't say anywhere that they have laid down a rule that properties acquired during a marriage will be shared 50-50 on dissolution of the marriage. So let's read to buttress that point before we go to rule number 2. So this is what the Supreme Court said. There appears to be the notion that someone has said that under Ghanaian law, following the coming into force of the Constitution 1992, a wife is entitled on dissolution of a marriage automatically to 50% share of any property acquired during the marriage. The impression that the law was changed in the Constitution emerged following a judgment of the Supreme Court in the case of Mensa and Mensa, 1998-99, Supreme Court of Ghana Law Report 350. That's Mensa number 1, Mensa number 1 versus Mensa number 1. After the decision, courts before the Supreme Court started sharing properties on dissolution of marriage on 50-50 basis. So it became necessary for the Supreme Court to clarify and restate the position of Ghanaian law on distribution of property on dissolution of marriage. The occasion was in the case of Mensa versus Mensa. So that's another case. That's in the case of Mensa versus Mensa in 2012. Note that the parties were completely different and unrelated to those in the earlier Mensa versus Mensa case. In rendering the unanimous decision of the Supreme Court in Mensa versus Mensa number 2, the court, Koram, Sofa Kufu, Dateba, Adinyira, Doche, Akoto Banfo, justices of the Supreme Court, clarified the position in the following words at page 408. So we'll read what the clarification is. So that is to say, the Supreme Court is saying that they clarified the position in 2012. So those who were still saying that the earlier Mensa versus Mensa case, 1998-99, had said it's 50-50, have no basis because the Supreme Court clarified the position as far back as 2012. So let's read what the Supreme Court said in 2012. They said, therefore, even though Boafo versus Boafo affirmed the equality is the equity principle as used in Mensa versus Mensa, it gave further meaning to Section 21 of Act 367 and Article 22, Clause 3b of the Constitution 1992. Consequently, the issue of proportions are to be fixed in accordance with the equities of each case. The court duly recognized the fact that an equal, that is half and half distribution, though usually a suitable solution to correct imbalances in property rights against women, may not necessarily lead to a just and equitable distribution as the Constitution and Act 367 envisages. It is submitted that the court made room for some flexibility in the application of the equality is equity principle by favoring a case-by-case approach as opposed to a wholesale application of the principle. Right. So this is the quote. So you hear case by case, meaning that we must look at the facts of each case, and no two cases are the same. We must look at the facts of each case and decide. So that's what we mean by case approach. It's not an automatic case that every dissolution of marriage, where are the properties? 50-50, pam, the gavel is down, case closed. No. So this is it. The Supreme Court clarified this position in 2012, but still some lawyers didn't read it well, and so the misconception endured, so much so that even in 2013 the Supreme Court had to clarify again. Let's state it again. That's a clarification. So the Supreme Court says here, so simply put, what the court said above in Mensa versus Mensa number 2 is that in some circumstances equitable distribution may end up resulting in 50-50 proportions, but in other circumstances it will end up like 60-40 or some other proportion. Stated the other way round, 50-50 distribution in some circumstances may be equitable, but in other circumstances it may be inequitable. A distribution of property upon dissolution of marriage that is inequitable would violate the clear provisions of Clause 3b of Article 22. Therefore, the proportions of distributions shall be on a case-by-case basis. That is it. So the Supreme Court is telling you that the Constitution 1992 never laid down 50-50 proportions. No. So hopefully this should put this matter to rest. So the court goes on. I think we would go back to explanation so that we don't have to read further, because the court goes on to further explain over and over. But the point I wish to make from the explanations over and over is that the Supreme Court is very clear that don't say anywhere that they have ever decided that it is a 50-50 distribution of marital property. No. Now, the next thing we should be looking at is the next point as part of the rules that the Supreme Court wants us to note is that when a marriage is dissolved, let's note this, when a marriage is dissolved, so let's call it rule number 3 for today. When a marriage is dissolved, the court also, in determining the distribution, that's in dividing the property or distributing the property amongst the parties, would also look at satisfactory services provided by one party to the other. You say, so the point is this. Let's say, for example, and typically, let's use let's not use the stereotype. I'll turn it. So let's say it's the woman who works. The husband stays home to take care of the children. It's the husband who cooks, washes, cleans the house, etc. And the woman is a high flyer, so she does very well. She's the one who works. So what the court is saying is that on dissolution of the marriage, you cannot say that because the husband wasn't working in any formal employment and earning income, he has not contributed to the acquisition of any properties that the woman who works has built. Says that is wrong. That is wrong because the husband, by also staying at home, cleaning, taking care of the children, picking them up from school, etc., has also performed satisfactory services. So the court will look at those services and then decide to give part of the properties that the woman has earned or has acquired through her employment or business to the man. So that is very, very key. Don't say that the husband never held a formal job, so he didn't bring in any money. No. That is not our law. And it has never been our law for decades, because the courts have always been clear that it's not always about going to earn formal income and bringing it before you will be deemed to have contributed. No. Domestic services also count. But some decades ago, we used to misapply the law. But now that misapplication is gone down drastically. Yes. So hopefully we are making progress. So that's our rule number 3 for today. So let's read a bit of what the Supreme Court stated just to buttress this point. It says, the evidence led in this case stated above, and our opinion of the totality of the evidence is that the wife did contribute to the acquisition of the properties. The law no longer requires a spouse to prove direct pecuniary contribution in the form of paying part of the purchase price of the property from her own money or buying part of the building materials in the case of a house. In this case, the wife testified that she was working and earning income, first as an employee and later as a businesswoman operating a hairdressing salon and importing goods from Ghana for sale. From these earnings, she said she maintained the home, and though the husband counted that it was done for only a brief period, we are inclined to accept her testimony because if account is taken of the extramarital commitments of the husband, that would have shifted a lot of the domestic burden on the wife. Emotional support and satisfactory matrimonial services by a spouse are also elements of contribution to the acquisition of assets during a marriage. In this case, the documents filed on the properties by the husband show that he involved the wife to sign some of the documents, and some of the properties were already acquired in the joint names of the husband and the wife. This for us can only mean a recognition of the husband of the assistance in whatever form he got from the wife in the acquisition of the houses. We therefore disagree with the Court of Appeals analysis of the evidence of the wife's overall contribution to the acquisition of the properties in question. Good. So you see it. The Supreme Court has been very clear. I think I don't need to repeat again. Now, let's go to rule number 4. So, what we should be looking at here is that it's also not the case that every property that is acquired during marriage can be classified as marital property. No. Put it in another way. When parties are married and one of the parties has gotten some resources and wishes to acquire a property, that party is free to do so and acquire it in that party's name alone. So it doesn't follow that once you are in a marriage, every property you acquire should be in the names of both parties. No, husband and wife. No, you are allowed to acquire your own property. But just remember that if it turns out that because, let's say, the example I gave, let's continue to use it. The husband is the one at home and doing all the chores. So the wife chooses to acquire all the properties in her name. So let's say she buys 10 houses in her name. Yes, the law allows her to buy in her name. It doesn't always have to come in both names, no. But on dissolution, it cannot be said that because all the 10 houses are in her name alone, she alone will keep them. No. As we stated earlier, because the husband is the sit-at-home husband, and so that's all the chores and etc., the court will look at the 10 properties acquired by the wife and give him something reasonable depending on the work that he did. Of course, when we keep referring to houses, it's not only houses, it also applies to investments, maybe treasury bills, bank accounts, gold, etc. Any properties at all. But a lot of the time I think we like to use houses because houses are very popular in the context of distribution of properties in a marriage. Okay, so that is it for rule number 4. Okay, so let's also note rule number 5. Now, there is this practice where some spouses, in order to dodge the distribution of properties upon dissolution, they will set up a company, okay, where they acquire properties through the company. So husband and wife, like in this case, the husband had a certain property and he used the company to buy some of the houses. So in law, the houses belong to the company because it's the company that buys, and the company puts those houses on its books, so the accounts, etc. It's quite a popular practice that some men, especially when it comes to that one, is the men that are noted for doing it. But I'm not saying that women too don't. But so far, all the cases we've seen is the men that set up the companies and do this. The courts are very clear. Even when you set up a company and use the company to buy the properties, it's the same rule. When it comes to the dissolution, the court will go into it. They will not say because of separate legal personalities, because the company has a separate legal existence from the husband, then you cannot touch the company if you want to go and sue the company alone. No. That sometimes it exists, but in the divorce cases now, most of the time, the court will just deal with the case once and for all. So in this case, the court didn't say because the company has a separate legal existence and the company was not sued, they cannot distribute their properties. The court just went ahead and distributed the properties, notwithstanding the separate legal personality. So note it. And this is not the first time. It's also done also even in England. There are some cases from England that also support this principle. So if your plan is to use a company to acquire everything so that you can escape from the justice of the law, sorry, that won't happen. And this is not the first case that this has happened. This Anyete versus Anyete is not the first one. I remember Akutu versus Akutu, the minister for Agric, former minister for Agric. Yes, his divorce case, this matter came up. He acquired some of the properties, company names, etc. But the Supreme Court said no. They went ahead and distributed the properties. So beware those who would think that setting up a company totally absolves you. No. But of course, it's also about evidence. If a company is set up and it's genuinely working and it's not income that the husband takes and just uses to buy properties in the name of the company can come forward to show how it is so independent of the husband and wife. But even in that case, then the question will be that, okay, what does the husband or the one who owns the company, what does the person own there? So the court will assess what that person owns and still give something reasonable to the other party. So basically, the point is that just setting up a company and running it, using it to acquire properties, or going to put your investments in a company with other people will not insulate you from being asked to give part of whatever you own in the company to your spouse. That's the whole point. So then the rule number 6 for today. It's also the point that if you acquire properties using loans, don't also think that just because you acquire the property using a loan and the fact that a loan is still running at the time of divorce, then that means that the court cannot touch it. No. Let's put it in another way. When we say loan, so let's use a common example. Let's say you take a mortgage. So you bought a property, but with a mortgage. So that it means that the property is still in the name of the bank from which you took the loan and will continue to be in the name of the bank until you finish paying. Good. So if you have such properties, it doesn't mean that when you go to court, you can just show the court that, hey, my lord, this one is a loan. No. Have you seen these documents? The property belongs to the bank. You see, it's the name of the bank, so you cannot touch it. No. The same principle as I stated earlier. The court will assess how much you've paid, what is left. Then the court will see and weigh to see how the other party, that's to say if it is the wife, in this particular case, Anyete is the husband who used the company to buy properties and got the mortgage. So the court looked at it and saw that, if we give these properties to the woman, that's Susanna, she can pay off the mortgages and then take the properties. So the court did that. The court said, okay, yes, even though this property is still in the name of the bank, there's a mortgage on it, still we'll give them to Susanna, so that Susanna, you also know that you then have to continue the payments. Otherwise, if you don't pay, then that one, the bank will dispossess you, they will foreclose and take the property. Okay? Yes, so that's very, very critical. Good. So to buttress it, let's read a little bit from what the Supreme Court said about these mortgages. This is what the Supreme Court said. We notice that in distributing the houses in this case, which are of varied estimated values, the High Court judge was influenced by the principle of equal sharing. However, since some of the properties in South Africa were subject to liabilities in the form of loans outstanding to be paid on them, asking one spouse to pay off the loans on properties given to the other spouse, while at the same time bearing the loans outstanding on the properties given to him, would likely tilt the balance against that spouse having to bear all the liabilities alone. For that reason, we do not approve of the order by the Court of Appeal for the husband to pay off the liabilities outstanding on the properties given to the wife. So you say, point made. So the wife takes the properties and then she can also pay off the mortgages. So I think that with this, we should be able to see our way clear in distributing marital properties. Yes, and then let's also mention the matter of alimony. Yes, so alimony is usually cash, or it can also be property, but that is usually the money given to the other spouse. So that is to say, the less well-off spouse, okay, as a way of maintaining that spouse. So in the Anyete case, the court set the alimony at $50,000. Yes, $50,000. And so the husband had to pay. But please remember the principle that it's not always the man who has to pay to the wife. In the case that it is the wife who works and has all the money, it will be ordered that she pays that money to the husband. Okay, so now the next thing is about owning shares in a company. That's the last rule for today. So maybe we can call it rule number 8. So note that once one of the party owns the shares in a company, what the courts are saying is that you simply, and we've earlier on explained the principle of separate legal personalities, right? But one of the parties owns shares in the company. So in that case, what will happen is that, so let's say the wife, so the example we're using today consistently is a wife who is working and the husband is home. So if the wife owns, let's say, 30% shares in TV3 Ghana Limited, just as an example. So what the court is saying is that in that case, then an order can be made that the husband be given, say, 10% of the shares. Simple. Yes, the court will make that order. 10% of the shares be given to the husband, and that will be fair. So once again, let's not just say that, TV3 Ghana Limited was not made a party to the divorce proceedings. TV3 was not before the court, so you cannot make an order that the wife should give 10% shares. No, it doesn't work like that. It's the wife who is holding 30% shares in TV3. And so out of the 30%, the court can make an order that 10% be given to the husband. And once that order is made, the company law rules that have to be followed for the 10% to be given to the husband can be followed. And that doesn't cause any injustice. There are rules to be followed. Once the court order is made, the company secretary and the directors of TV3 Limited will know how to go about it and give the 10% shares to the husband. So I think that this would be the end of today's episode. Thank you very much. I hope this has been very useful and enlightening. I'm looking forward to your comments, and I'm also looking forward to another episode of Court Rise with me, Martin Kpebu. Thank you very much for your attention.